regarding a medical certificate, the ship owner shall not embark a seafarer which has not a medical certificate proving that the seafarer is fit for duty on the vessel by a doctor of the medical center with a higher grade than the hospital under the provision of the medical law or clinic appropriate to the standard set out in the ordinance of ministry. The issuance of a medical certificate and other necessary measures for the medical examination shall be prescribed in the ordinance of ministry. For a foreign seafarer, if he or she holds a valid medical certificate, then it shall be accepted. Therefore, a foreign seafarer needs not to obtain an additional medical certificate in Korea. So, if you hold your medical certificate in your country, then that will serve the purpose. Talking on the medical advice by radio communications, etc. First, where the master of a ship, including a foreign flag ship, navigating around the waters of the Republic of Korea, request Minister of Oceans and Fisheries to give him or her medical advice on a seafarer who is injured or affected by a disease. The Minister of Oceans and Fisheries shall give him or her medical advice free of charge by radio or satellite communications. Second, to give medical advice as under paragraph 1, the Minister of Oceans and Fisheries shall request that the Minister of Health and Welfare, who establish and operate Emergency Medical Service Information Center pursuant to Articles 27 of the Emergency Medical Service Act, cooperate with him or her, and the Minister of Health and Welfare shall cooperate with him or her unless there is an unavoidable reasons. Third, where a foreign injured or sick seafarer who has entered a domestic port request that the Minister of Oceans and Fisheries give him or her medical treatment, he or she shall take necessary measure for him or her to take medical treatment. With respect to prohibition of night work and menstruation holiday, first, a ship owner shall not have a seafarer under 18 years of age engaged in work for at least 9 hours at night, including hours from midnight to 5 in the morning. Provided, however, that this shall not apply where the ship owner has obtained consent of such seafarers and approval from the Minister of Oceans and Fisheries as easy work. Second, the main sentence of paragraph 1 shall not apply where a ship owner has a seafarer engaged in work under Article 60, paragraph 6, or a ship on which only a family being in service on board. Third, for menstruation holiday, a ship owner shall grant female seafarers a menstruation holiday of 1 day per month if women seafarers request. Chapter 8 prescribes penalties. Regarding penalties for master, crew, first, where a master abuses his or her authority to force a seafarer or person on a ship to do work that he or she has no duty to engage in, or to prevent seafarer or a person on a ship from exercising his or her right, the master shall be punished by imprisonment for not less than 1 year, but not more than 5 years. So therefore, the master shall not abuse his right. Second, the master who does not take all measures necessary to rescue human lives or causes the death of a person on board by leaving his or her ship without taking all measures necessary to rescue human lives. In this case, imprisonment for life. This is life imprisonment, or for not less than 3 years. This is very heavy punishment. Third, a crew member who does not take all measures necessary to rescue human lives or causes the death of a person on board by leaving his or her ship without taking all measures necessary to rescue human lives, imprisonment for not less than 3 years. Therefore, when you are serving on Korean flag ships, you must bear in mind that very heavy imprisonment punishment is imposed if you are not taking your jobs to rescue any human lives, etc. Fourth, a seafarer who does not take all measures necessary to rescue human lives or cause the death of a person aboard by leaving his or her ship without taking all measures necessary to rescue human lives, imprisonment for not less than 1 year, but not more than 5 years. And fifth, a seafarer who causes damage to a ship or cargoes by not taking all measures necessary to rescue the ship and the cargoes, imprisonment for not more than 1 year, or a fine of not more than 10 million wons. In relation to penalties for master, first, a master who causes the death of a person aboard but not taking all measures necessary to rescue human lives, imprisonment for life or for not more than 3 years. Second, a master who injures a person aboard by not taking all measures necessary to rescue human lives, imprisonment for not less than 5 years, but not more than 1 year. And third, a master who doesn't take all measures necessary to rescue his or her ship, imprisonment for not more than 1 year, or a fine of not more than 10 million won. Fourth, a master shall be punished by imprisonment for not less than 3 years, or a fine of not more than 30 million won, when he or she falls under any of the following cases. Where he or she fails to take all the necessary measures for rescue of human lives in violation of Article 13, where he or she abandons a ship, or where he or she abandons a crew in a foreign country. Fifth, a master shall be punished by imprisonment for more than 1 year, or by a fine of not more than 10 million won, when he or she falls under any of the following cases. 1. When the master violates the responsibility for inspection before departure from a port, etc., under Article 7, Para 1. Second, when the master doesn't present reports or make false report under Article 7, Para 2. When the master doesn't request the measures under Article 7, Para 3. When the master changes the planned sea route in violation of Article 8. 5. When the master does not command the steering of the ship directly in violation of Article 9, Para 1. When the master leaves his or her ship in violation of Article 10. 7. When the master violates the responsibility of ensuring safety of navigation under Article 16. 8. When the master buries a dead body at sea in violation of Article 17. 9. When the master refuses to repatriate a Korean citizen in violation of Article 19, Para 1. 10. When the master prepares and keeps falsified documents under the sub-paragraphs of Article 20, paragraph 1. 11. When the master files false reports about cases under Article 21, or 12. When the master refuses the request to treat injury or disease of seafarers in violation of Article 82, paragraph 6. In relation to penalties for seafarers, first, a seafarer who assaults or treats his or her superior or senior shall be punished by imprisonment for not more than 3 years or a fine of not more than 30 million won. Second, a person who goes on a strike in violation of Article 25 shall be punished according to the following classification. First, a person who leads a strike or play a leading role, imprisonment for not more than 3 years. Second, a person who actively participates in conferences for a strike or instigates a strike, imprisonment for not more than 1 year, or a fine of not more than 10 million won. Third, in cases falling under paragraph 2, where a person goes on the relevant strike by reason that a ship owner, including his or agent, violate acts and subordinate statutes against interest of seafarers or violate seafarers' employment agreement without a justifiable reasons, he or she shall not be punished. Where a ship owner or seafarer falls under any of the following cases, he or she shall be punished by the imprisonment for not more than 5 years or a fine not exceeding 50 million won. Where a ship owner or seafarer violates the provision of Article 25 with prohibition of forced labor, where a seafarer falls under any of the following cases, he or she shall be punished by imprisonment for not more than 1 year. Where he or she leaves a ship without a master's permission, where a ship is in critical danger, or where he or she fails to obey an official order of his or her superior, senior, where a master take necessary measures for the rescue of human lives, a ship or cargoes pursuant to Article 11 through 13. Regarding negligence fine, first, a person who comes under any of the following items shall be subject to a negligence fine of 5 million Korean won or less. First, master who does not perform exercise drills. Second, a master who does not render the information necessary for passengers aboard to evacuate in case of an emergency. Third, master who shortens hours of seafarers' rest for the reason of conducting emergency drills. Second, a person who falls under the following subparagraphs shall be punished by a fine of not more than 2 million won. Master who provides meals in a discriminating way. I explained very detail about the penalties in Seafarers Act. Well, these penalties actually originate from old Korean legal system. Recently, at IMO, the international community adopted to gradually take less penalties or eventually eradicate all the penalties for seafarers. but at current, Korean seafarers prescribes very detailed criminal penalty provisions in the Act. This is sort of matters that need to be resolved in the future. Let's have some break, and then let's come back to part 2 of this session. Turning now to part 2, the System of Ship Officers Act. I would like to talk about the following areas in the Ship Officers Act, namely general provisions, certification system, ship officers, and supplementary rules and penalties. Firstly, we need to identify the relevant laws, regulations, ordinances, and notices relating to the certification and maritime education and training system in Korea. The following are the relevant ones, i.e., Ship Officers Act, Enforcement Decree, Enforcement Ordinance, the quality standards, the standards for the recognized education and training institutes, and rules on training record books. Korean laws and regulations are in full compliance with the relevant requirements under the STCW Convention as amended. The Republic of Korea ratified and implemented STCW Convention as amended, but it has not ratified the STCWF Convention. However, Korean laws and regulations meet most of requirements of the STCWF Convention, except minor ones. Therefore, the ROK would be able to ratify the STCWF Convention in the near future. As you may know, STCW Convention 1995 are in full revision process. Therefore, Korea is to participate in the process of revising STCWF Convention and will be quite ready to ratify F Convention as well. The Chapter 1 in the Act sets out general provisions. Firstly, you have to understand and keep in mind the purpose of Ship Officers Act is to ensure the safe operation of ship by establishing the qualification standards of those who are to serve on board vessel as ship officers. Why are you required to complete compulsory education training courses, sit for exams, and obtain necessary certificates, including a certificate of competency, certificate of proficiency, and documentary evidence? That is to ensure the safe operation of a ship. Thus, you have to keep this in mind always. Talking on some of the important definitions under the Act. Firstly, on the definition of vessel, it means every Korean vessel except the following. First, a vessel under 5 gross tons, except vessels carrying 13 passengers or more. Fishing vessels filed for providing pickup service for anglers, and pleasure boat and ferry boats certificated or filed its trading area at sea. Therefore, Ship Officers Act are not applicable to very, very small vessels. But if they carry people on board, then the Ship Officers Act is applied to them. Second, a wing-in ground craft. There are few wing craft in Korea. Therefore, we expect that there could be a certain need of the wing craft operators in the near future. Third, a vessel propelled mainly by oar or foil. This means that Act is applicable to vessels with propulsion power or sailing power. Fourth, any other vessels as provided in the presidential decree. The decree actually provides laid-up vessels of less than 500 gross tonnage. Thus, the Ship Officers Act is applicable to laid-up vessels of 500 GT or above. Now, you gotta understand that the definition of vessel is directly related to the scope of application of the Ship Officers Act. Secondary, Ship Officers Act, secondary ship officer means any certificated officer, including any officer endorsed in accordance with Article 10 bis, who serves on board a vessel in a capacity or capacities of master, deck officer, ship engineer, engineer officer, ship radio officer or radio officer or operating officer. On the other hand, certificate officer means a duly qualified officer holding a certificate of competency. I am not currently serving on a ship, but I do hold certificate of competency. Therefore, I am a certificate officer, but I am not ship officer. As you can distinguish between ship officer and certificate officer. Thus, when you are saying a ship officer, he or she must have a capacity on board of one of the master, deck officer, ship engineer, engineer officer, ship radio officer or operating officer, etc. In order to serve as a ship officer on board, you have to hold a relevant certificate of competency, and the valid COC must be carried on board in order to cope with various controls, including the port state control. Turning to Chapter 2 about certification system. Firstly, in relation to the species and classes of qualifications in Korea, there are 7 species of COCs, namely Deck Officer Certificate, Engineer Officer Certificate, Electrotechnical Officer Certificate, Radio Officer Certificate, Operating Officer Certificate, Weak Craft Operator Certificate, and Small Vessel Operator Certificate. Secondly, regarding classes of certificate, Deck Officer Certificates consist of from 1st to 6th classes of COCs, and they are again classified into merchant ships and for fishing vessels certificates, which means there are 12 kinds of Deck Officer Certificates. Engineer Officer Certificates consist of from 1st to 6th class of COCs. However, they do not distinguish merchant ships or fishing vessel certificate as such. Electrotechnical Officer Certificate is a new certificate introduced for implementing Manila STCW amendment adopted in 2010. In Korea, this new certificate is not popular yet. Radio Officer Certificates consist of from 1st to 4th classes of COCs, and they are classified into Telegraphic Officer, which means Morse Officer, in other words, and Electronic Officer, GMDSS certificates, in other words. Operating Officer Certificates consist of from 1st to 4th classes of COCs, whose holders perform integrated operating watch in automated vessels. Weak Craft Operator certificates are classified into 10 maximum take-off weight weak craft operator, or 10 to 500 maximum take-off weight weak craft operator certificates. Finally, small vessel operator certificate is issued to those on board a ship of between 5 to 25 and 25 GT. Turning to conditions for issue of a certificate of competency. A candidate shall meet all of the following. A candidate must have passed the National Ship Officers Examination within 3 years upon passing the exam. This means that validity of past exam is limited to maximum of 3 years from the passing of the exam. A candidate must have completed approved 시공 service required. And candidate must meet standards of medical fitness for duty, and candidate must have completed approved maritime education and training required. In the case of certification for radio officers, a person who has the qualification for radio personnel pursuant to provision of Article 70 of Radio Wave Act. With respect to method of examination, deck engineer or operating officers exams are conducted both in written and oral. However, the exams for class 3 and below of these certificates are conducted written only. For radio officers certificates exam are carried out oral only. For small vessel operator certificates, exams are conducted in written, oral, or practical test. Regarding exams for foreign officers endorsement, oral test only. However, if a foreign officer has completed relevant training course, the oral test will be exempted. The subjects of examination for deck engineer, radio, operating officers, etc. are set out in the special table 2 of the presidential decree. The detailed ratio of questions for each syllabus of subjects are set out in the notice of the Minister of Oceans and Fisheries. The Minister may break down and specify in detail the syllabi of the examination subjects. Regarding the relevance of certificate of competency, a candidate shall meet any of the following requirements. First, approved seagoing service of at least 1 year as a ship officer during the preceding 5 years from the date of application for the revalidation. Approved seagoing service of at least 3 months within 6 months from the day of expiry as a ship officer, or approved seagoing service of at least 2 years as a rating. Second, equivalent shore experience of at least 3 years during the preceding 5 years from the date of application for the revalidation. Or third, completion of an approved training course. This slide shows schedule for revalidation of a COC. There are 4 choices that a candidate can apply for revalidation of their COC. First, a candidate can submit an application within date of 6 months prior to the expiry date and expiry date, in which case the validity of a new certificate can be extended till 5 years from the expiry date of existing certificate. In this case, validity of a new certificate shall be up to 5 years and 6 months. This is in line with revised STCW convention. Second, a candidate can submit an application after expiry date of existing certificate, in which case the validity of a new certificate can be extended 5 years from the date of revalidation. Third, a candidate can submit an application within 4 years from the issuing date of existing certificate and the date of 6 months prior to expiry date, in which case the validity of a new certificate can be extended 5 years from the date of revalidation. Fourth, a candidate can also submit an application any date prior to 4 years from the issuing date of existing certificate, in which case the validity of a new certificate can be extended 5 years from the date of revalidation. If a candidate does not have necessary seagoing service or equivalent shore experience, then he or she needs to undergo a renewal training course, in which case he or she shall submit an application within 12 months upon the completion of the date of the renewal training course, and the validity of a new certificate can be extended 5 years from the date of revalidation. Therefore, one must not forget the importance of carrying necessary COC, COP, documentary evidence, and holding valid certificate while on board. Otherwise, your ship would be detained at any port of call by the port state control officers.